Um, Great. Hi, everyone. Thank you all for coming to our webinar, which, if you didn't catch that, it is being recorded. Um, Comstock conflict on the new Trump administration. This webinar is a companion to an online symposium we at Boston University Law Review recently published. Um, Me and my co-online editor, Sherry Huber, were sort of in charge of that process. And that symposium was on Reva Siegel and Mary Ziegler's article, Comstockery, which is forthcoming to Yale Law Journal. So in addition to being a formidable piece of scholarship in its own right, Comstockery is a useful tool for understanding the future of attempts to restrict access to abortion. So we reached out to other scholars looking to comment and expand on Comstockery's themes, and sort of think what the fight over abortion access is going to look like in the new Trump administration. So today, in addition to Reva Siegel from Yale Law School and Mary Ziegler from UC Davis Law, who are the authors of Comstockery, and Linda McLean from BU, who's moderating our panel, we also have Serena Mayeri from the University of Pennsylvania, David Cohen from Drexel University, Laura Portuondo from the University of Houston Law Center, and Nicole Huberfeld from Boston University. So with that, I'll hand it off to Professor McLean to moderate. Thank you all for coming.
Good morning, everyone, or lunchtime, everyone. I'm co-director of BU's program on reproductive justice, along with Nicole and Aziza Ahmed, and we're delighted to be co-sponsoring this program on Comstock conflict in the new Trump administration. So I'd just like to explain to you the format we'll be following over the next 90 minutes. We're going to begin with a presentation by Reva and Mary of about 20 minutes of their article Comstockery. We'll start with Reva, then Mary, then Reva will finish up. We will then have commentaries by Serena Mayeri and David Cohen of about 10 minutes each. We'll take a quick break for any questions about the first two presentations. And then we will have commentaries by Laura and Nicole. We will then open it up for discussion, and we'll reserve 10 minutes at the end for Reva and Mary to offer any final thoughts based on the conversation. So I'd like to begin then by turning it over to Reva Siegel and Mary Ziegler.
Okay, first of all, we just wanted to start out by thanking Linda McLean and Jim Fleming and Michael Bruin and Sherry and the BU Law Review for organizing the online symposium on this paper, and Aziza and Nicole in the center for organizing the webinar today. It's taken a lot to bring us here and to bring together the remarkable group of commentators both online and in the webinar today, and we're grateful for everyone's engagement with the work and with the question of Comstock revivalism, which we will dig in. And I will say it's been a remarkable journey with Mary since we decided that the question warranted some kind of engagement. It's been quite an engagement. So I'll start in. We're going to switch back and forth while we talk about the paper. So since Dobbs, there's been efforts to enforce the abortion provisions of the Comstock Act, and it's, as many people know, an 1873 postal obscenity statute, and the effort has been to present it as a no exceptions national ban on abortion. These claims have appeared in a lawsuit that the Supreme Court dismissed for lack of standing in June, and in plans for the Trump administration about to begin in the so-called Project 2025. And yesterday, Judge Kaczmarek, a Trump appointee in Amarillo, Texas, issued an order, who we know as having issued an order banning medication abortion back in 2023, in the case the court just addressed and dismissed because the plaintiffs lacked standing. This judge actually just attempted or acted to continue the suit by allowing 3 states to amend the complaint and continue the action, even though the states seem to have little in connection with his court venue in Texas. The states are Missouri and Idaho and Kansas, all to consider about the role of courts in this story. To continue. So Our paper explores it's called Comstockery, and the longer title, How Government Censorship Gave Birth to the Law of Reproductive and Sexual Freedom and May Yet Threaten It, explores a legal history of the Comstock Act that focuses on the postal obscenity law's regulation of contraception and abortion. And we undertook this history of the statute, frankly, because we had little reason to credit the litigants' claims on the Comstock Act. So we started out thinking that we were responding to these claims, but the paper that appeared is much more than a rejoinder to the claims for the invented past we call Comstock revival. We analyzed the statute as contemporaries understood it, that is, as an obscenity law, and illustrate how and why understandings of obscenity changed after the law was enacted. The postal statute was the first federal obscenity law to include writings and articles that facilitated contraception and abortion. Its coverage was never absolute. Those who drafted and enforced the law understood it to prohibit obscenity, not healthcare, a distinction whose meaning evolved over time. In the late 19th century, there were folks who agitated for sexual purity and helped expand those understandings of obscenity. And in turn, there were there were in particular opponents of the statute who helped shrink the understandings of obscenity in turn, and help shift understandings of obscenity that the law prohibited and of healthcare that it protected. So resistance to Comstockery gave birth to modern understandings of democracy, of free speech, of sexual freedom, and of reproductive freedom, we point out, first under the statute in the 1930s and ultimately under the Constitution. And Mayeri's going to start out by talking to us about the statutory understandings we uncovered.
So as Reva mentioned, I'm going to talk first about the statute. Our account, we think, first makes clear that contrary to what revivalists have said, the meaning of the Comstock Act's abortion provisions, which refer to unlawful abortion in the portion not about mailing, and to the procuring of abortion in the portion that does refer to mailing, have never been plain or absolute. As we show, the text of the statute as it was enacted in 1873 and as it's codified today doesn't contain a categorical ban on mailing materials for terminating pregnancy. At the time of enactment, procuring of abortion was a crime. An allegation of unlawful intent could make the termination of pregnancy or miscarriage a crime, but not if undertaken to save a life, a question that physicians had a lot of discretion to determine. We argue that the statute's postal provisions had two scienter requirements, requiring that a sender knowingly mail items first, and second, that they had an awareness that they would do so knowing that the items would be used unlawfully. These two requirements, we think, remain in the text of the statute as it's been amended and codified. In fact, judges over time responded to these statutory cues, even in the 19th century and particularly in later years, as they distinguished between obscenity on the one hand and health on the other. Significantly, even at the height of what we call a sexual purity regime, courts reasoned that the Comstock Act's provisions didn't apply to some parts of the doctor-patient relationship, even as the kinds of exempted health-related mailings evolved over the life of the statute. So what did postal inspectors and judges understand to be obscene under this arguably and clearly vaguely written statute? As we show, the answer changed dramatically over time. The Comstock Act had destabilized understandings of obscenity for the first time, including writings and paraphernalia related to birth control and abortion. It was unprecedented, too, in the sense that the government was seeking to prohibit or regulate non-procreative sex within marriage, not just sex outside of marriage. The Comstock Act was enacted at a time of plummeting birth rates, surging immigration, and a growing movement for women's suffrage, and it inserted the federal government into Americans' intimate lives in unprecedented ways. At the same time, its scope remained unclear, even to the legislators who enacted it. Its convoluted text then provided flexible authority for postal inspectors, social movements, and courts in the years to come. In the first decades after its enactment, a sexual purity movement mobilized to persuade the government to adopt its understanding of the law and to enforce it to ban an ever-growing array of things related to sex, contraception, and abortion, and to target for prosecution in particular those who criticized the statute and advocated for its repeal. By the early decades of the 20th century, we show women suffragists and other opponents of the Comstock Act began to conscientiously court arrest, and growing numbers of Americans across the nation came out vocally to oppose the government's extreme interpretations of obscenity. By the 1930s, federal courts, responding to the public's alienation from sexual purity interpretations of the law, began to read the postal statute with attention to its double scienter requirements and to characterize a broader category of things as legitimate forms of healthcare exempt from criminalization under the statute. These included not just direct exchanges between physicians and patients, or even books about sex education, but also condoms and diaphragms, all of which were reframed as integral to Americans' health. By distinguishing obscenity from health, judges adopted what we think is a fair reading of the statute's language that responded to decades of judicial discussion, as well as decades of popular resistance that enforcers of the statute had tried to censor. There was consensus from the beginning that the statute didn't cover all forms of health, even as courts' understandings of the distinction between obscenity and health evolved with American public's understanding of democracy, freedom, family, and the Constitution. It's for this reason we think that the history of the Comstock Act unearths lost popular roots of modern First Amendment, sexual liberties, and reproductive liberties laws. So in this sense, we're telling a bottom-up story about change. But we think that the history of the Comstock Act is also a story of a statute that was entrenched against change by profoundly anti-democratic forces. Federal obscenity laws like Comstock, as well as their state equivalents, were first enacted and then later preserved on the books using government action that we would view today as unquestionably unconstitutional. Criminal prosecutions under the federal statute and state obscenity laws persisting from the 1870s into the 1930s, and even in some instances until the 1960s, that stigmatized what we would now unquestionably view as political speech, as well as intimate behavior and reproductive decision-making, all of which were marked as obscene, dirty, immoral, and unworthy. As we show, women's political marginalization and the Comstock Act's stigmatization of speech about sex and reproduction interacted over the decades and together helped to prevent the law's reform or repeal. Comstock revivalism, which we track in the book, which emerged in the aftermath of the reversal of Roe, is very much a product of the historic moment created by the Dobbs decision and the backlash it produced. Following the demise of Roe, the anti-abortion movement declared the pursuit of constitutional fetal personhood to be its so-called new North Star, but voters have overwhelmingly opposed the policies of the anti-abortion movement, and polls have shown consistently record high support for abortion rights, numbers that seem to even exceed the high support before and after the court's decision in Roe. The Comstock Act has thus emerged as a strategy to achieve an abortion ban that Americans would never choose to enact. And our history shows that Americans never actually enacted the no exceptions abortion ban that Comstock revivalists champion today. These advocates have cherry-picked a handful of words from what remains a sweeping obscenity law and have ignored the inconvenient remainder. After editing out words that suggest the statute's preoccupation with sex, revivalists argue that the remaining text unambiguously covers all abortion. They failed to address key features of the statute's text and history. At the time the statute was enacted, for example, the term abortion was synonymous with miscarriage, and procuring of abortion, as we've discussed, refer only to some abortions, those not undertaken to preserve life or health. Moreover, the turn to the statute's history to clarify its meaning is warranted by the very ambiguity of the term abortion standing alone. If anything, in the present, it's groups opposed to abortion who are changing the definition of abortion in state statutes and otherwise, among other things to exclude life-saving procedures. So putting the pieces together, we can see that questions about the law's meaning and democratic legitimacy come together. Revivalists are employing a law enacted and preserved by what Americans now view as unconstitutional means to impose what they are saying is a law, but a law that in fact Americans did not enact and would not enact today. So I'm going to turn it back to Reva to talk about how this story taught us some lessons about our constitutional traditions.
Thanks, Mary. So we began this article with a goal of evaluating the revivalist claims about the Comstock statute that Mary's just been discussing. But over the time we were working with the materials, we began to appreciate that we were uncovering a fundamentally different perspective on Dobbs itself. So how would a story about conflict over the Comstock statute shed light on our Constitution? As we show, Americans resisted the government's unprecedented efforts to control their speech and intimate lives. And as they did so, they struck a responsive chord and began to elicit increasingly widespread public support for their efforts. In the late 19th century, when free lovers began to protest Comstock enforcement, they were largely viewed as fairly outside the mainstream, with the possible exception of Victoria Woodhull, who was a fairly notorious character. It would be great to tell stories, but we don't have time. But by the turn of the century, when suffragists and anarchists, civil libertarians, and birth controllers were beginning to court conscientiously to court arrest and by breaking Comstock laws, their arrests elicited a different response for the public. And the public spoke out on their behalf, and they began to speak about breaking Comstock laws in a different register. Americans were not only using contraception and abortion, there was, without any clear way to diagnose pregnancy in the individual case, very little clear line between the two practices. But also there was a sense amongst the public not only that this was something they themselves were doing, but that also this was something they had a legitimate claim on doing, that there was something that they could assert like voluntary motherhood, whether it was called a formal right or not, it was their prerogative. And also there was a very widespread set of practices of appealing to concepts of health, euphemistically or otherwise, to explain why they needed what they needed without government interference or prying. So a new round of cases made its way into federal courts, less marginal and more central to the lives of Americans. Mary Ware Dennett was arrested for publication of what was then a very popular sexual education pamphlet endorsed by many ministers and central cultural officials. Young's Rubber defended its right to trademark Trojan condoms, and a doctor in Margaret Sanger's clinic defended her right to import a pessary. And by the 1930s, their cases were appealed into the Second Circuit, which addressed their claims in ways that redefined the boundaries between let's just say obscenity and health on the one hand and the other under the Comstock statute, reasoning quite differently than judges in the era of the sexual purity movement, while at the same time scarcely mentioning the constitutional claims of a number of the advocates who brought the cases to the court. By including these Comstock laws in our telling of the nation's past, and by examining the statutes with attention to the views of the law's proponents and their opponents, their disfranchised critics, we learn something different in substance and method than Dobbs teaches us, that we're both approaching the question of our nation's traditions from a different practice, and we're learning something about the character of those traditions than Dobbs tells us. So if the past is to guide constitutional interpretation, as Dobbs urges, it's critical to ask not only why that's so, but as the article we're writing asks, whose voices are included in an account of the past that can guide constitutional interpretation today. Recovering these repressed constitutional memories is all the more crucial after Dobbs, we say, when the Roberts Court has declared that the abortion right is no part of the Constitution or the nation's history and traditions, in a decision that casts the authority of Griswold, Lawrence versus Texas, and other substantive due process decisions into doubt. Without a long pedigree in history and tradition to constrain it, the court has suggested, the kind of right to autonomy and intimate life recognized in Roe and Planned Parenthood versus Casey could license quote, could license fundamental rights to illicit drug use, prostitution, and the like, the court suggested in Dobbs, close quote. As this article shows us, however, Dobbs' history was at best partial. The court said nothing about federal and state Comstock legislation in its survey of abortion law, and derived American traditions from statutes and decisions about abortion in which women had no say. In other words, the court's turn to a granular kind of history failed to impose objective, fact-based constraints, instead enabling a selective account of the past that concealed rather than constrained the interpreter's value-based judgments. But if turning to the past can't free constitutional interpretation from value-based judgments, as Dobbs imagines, it can still serve as an aid to interpretation. This matters all the more now that the Roberts Court insists that the meaning of the liberty guarantee is going to be discerned from the text of statutes, and judicial interpretation going to explore them in granular detail. If we're going to participate in a project of this kind and look to evidence of the past in this way, then we want to, as the court is now suggesting, be very, very conscious about where we're looking and what kind of approach both to laws of the past and to voices of the past we're going to approach. To ask, whose voices are we going to empower to decide freedom's meaning for us today, and whose voices will we exclude? As our article shows, by expanding the evidence of tradition we examine, we may arrive at a fundamentally different understanding of freedom's meaning. Reasoning in fidelity to the historical record, we can see that the nation's traditions emerged out of resistance to law, as well as in lawmaking, and included ordinary Americans as well as lawmakers. Including the perspectives of the governed as well as their governors is critical in deciding how laws define the nation's history and traditions and why. Democratizing constitutional memory in this way demonstrates that the American people asserted claims about free speech, intimate life, and reproductive freedom long before courts recognized those rights under the judicially enforceable Constitution. The postal obscenity law came to demonstrate the kind of government overreach, or Comstockery, as our title evokes, that has taught Americans the meaning of liberty. It was people's acts of conscience, their willingness to speak out, to resist and break the law, and to endure arrest and incarceration, that helped build the foundations of our constitutional law. And if there's any feature of the Comstock story that warrants reviving, it is, we say, the voices of these forgotten authors of our constitutional present. Thanks.
Thank you for that beautifully timed 20-minute distillation of your much longer article. Thank you so much, Reva and Mary. And now we'll turn to our first commentator, Serena Mayeri. And I've noticed a few questions in the Q&A, but we're going to get to those a little bit later. So thank you and keep them coming. Okay, Serena Mayeri, University of Pennsylvania Law School.
Thank you. Thank you so much for including me in this symposium on this really wonderful and path-breaking article. I'm going to, I think, pick up a little bit where Reva and Mary just left off. I've been exploring recently how history should and already does play a critical role in constitutional interpretation and in legal and political advocacy for reproductive rights and justice after Dobbs. And I think Comstockery is a beautiful example of how reproductive injustice and feminist resistance are a really key and important site where a certain kind of critical history can have the most impact. So what do I mean when I say critical history? I think, contra what we see in the varieties of originalism and other kinds of reasoning from the past in the current Supreme Court majority's doctrine, critical histories can correct factual distortions and these kinds of selective and ideologically motivated histories that we're seeing, and can challenge originalism as a descriptively and normatively problematic method. the kind of critical orientation toward history that I'm talking about asks different questions of the past than the court asks in Dobbs, for example. It looks to, as Reva was describing, different historical actors for the answers, and it uses those answers for very different purposes. So among other things, critical histories use, as Reva has described, use the past as both positive and negative precedent. To paraphrase Peggy Cooper Davis, history can tell us not only about past practices that we should emulate, but also the mischief and injustice against which the Constitution protects us. In Reva's words, we can democratize constitutional memory by expanding the sources that we draw upon to interpret the Constitution. So not just white male propertied elites, but enslaved, disenfranchised people, women, and others. So I want to talk now about how Comstockery really exemplifies this kind of critical use of history and what it can, what the payoffs of that can be. So first of all, I think it's important to note that Comstockery's history that Reva and Mayeri have uncovered is really quite valuable for its own sake. And it also, as they were suggesting, has some immediate payoffs for statutory interpretation in this era of Comstock revivalism. So Comstockery shows that even during peak enforcement of the Comstock Act, it didn't apply in cases where pregnancy threatened women's lives and health, and it afforded doctors wide discretion to provide health care. Comstockery also reveals, as we've already heard, the Act's many incompatibilities with modern constitutional values such as liberty, equality, and freedom of expression. Comstockery shows how Comstock became an instrument of the sexual purity movement, which defended the hegemony of white Protestant native-born elite men, and importantly, a vision of fragile womanhood under threat from promoters of sexual and reproductive autonomy. And they make really clear in this piece that Comstock censored not only sexual expression, but also more generally political speech, especially by women who challenged sex-based inequality and subordination. The article makes really clear that Comstockers imposed a draconian sexual morality not merely out of Victorian prudery, but to suppress threats to their own political and economic power. The article shows how Comstock was and still is profoundly anti-democratic. Not only were women and most people of color excluded from the polity in 1873 when the Comstock Act was passed, but the implementation of the law made it an instrument of self-perpetuating repression. It suffocated dissent. Just as important is the excavation here of this fascinating history of resistance to Comstock. Comstockery shows how feminists advanced claims we usually associate with later social movement mobilizations, claims about rights to privacy and liberty and freedom of expression. And this is a history of resistance that has been completely erased from constitutional memory in ways that, as Reva has written, destroy the vernacular of resistance, making oppressive conditions appear to be legitimate and consensual. And those erasures have fed really damaging narratives about statutory and constitutional law. So, for example, that the right to privacy was manufactured from whole cloth in Griswold, or that women's right to equal protection is similarly sort of comes out of nowhere as the product of men's beneficence that has no grounding in history and tradition. I think it's also really significant that Comstock suggests at least a partial explanation for these erasures, that the lingering chill of Comstock combined with women's historic political exclusion to stigmatize and marginalize public discussions of sex and reproduction long after enforcement waned. So we can have, as Reva and Mayeri describe, a discussion of Comstock during oral argument in Griswold, but nowhere do we hear in Griswold about this history of both repression and resistance. So as we've been suggesting, the story of Comstock also underscores the critical importance of this democratization of constitutional memory. Comstockery advances a very different vision of history and tradition than the one embraced by Dobbs and the current supermajority, as Reva and Mayeri were suggesting. So the past here is providing both constitutional inspiration and also a cautionary tale. And I think it's significant that much of our modern constitutional equality law, particularly sex equality law, depends on seeing the past more as a negative precedent, a record of past wrongs against which the nation defines itself, in Reva's words. At the same time, the untold history of resistance to Comstock can serve as a positive precedent modeling constitutional commitments that we might emulate today. Now I'm going to start talking a bit about why I think that this type of analysis can be particularly helpful in combating the kind of history and tradition analysis that we see in Dobbs and other cases. So Comstockery's historical account, I think, very poignantly highlights the absurdity of holding 21st century Americans to 19th century laws enacted under anti-democratic conditions that were tainted by racism and nativism and misogyny. It exposes the hypocrisy of selectively relying on a narrow vision of history and tradition when, as Reva and Mayeri note in the article, in other contexts, like the Second Amendment, for example, the court's majority takes a much more capacious view of whose ideas and attitudes matter in constitutional interpretation. And Comstockery, I think, provides an answer to Dorothy Roberts' call to understand our present as deeply rooted in past practices that endure in an altered but recognizable form today. So in that spirit, I'll just close by noting a few striking parallels between the Comstock era that Reva and Mayeri describe and today. So they describe how it was white Protestant male millionaires who largely powered Comstockery, both its selective enforcement regime and its targeted attacks on feminists and other political opponents. Today, white male, now it's billionaires, underwrite the same sort of efforts. Racism, nativism, and misogyny now run rampant in our political discourse, and the Great Replacement theory posits that Jews are conspiring to flood the country with black and brown immigrants to overwhelm white Christian America. This is all very familiar. Prominent politicians now espouse women's divinely ordained family roles and embrace Christian nationalists' fantasies of theocratic rule. It's also significant, I think, that the technologies of law enforcement that Comstockers pioneered echo today in anti-abortion strategies. So think of the surveillance by families, friends, and neighbors incentivized by laws like Texas's SB 8, which empower anyone with abusive or vindictive motives to sue an abortion seeker for damages. Laws that punish so-called abortion trafficking, which inhibit not only actions in support of pregnant people's travel, but also speech and dissemination of information about reproductive health care more generally. As in the Comstock era, as Comstockery underscores, few or no prosecutions are necessary to chill those who would resist. So since Dobbs, we've seen these horrifying stories emerge almost daily about lives, health, and fertility endangered or lost needlessly because of abortion bans' chilling effects on the treatment of miscarriages, emergencies, and pregnancy complications, as well as abortions. Pregnant people, especially those who are more vulnerable to criminalization because of race and poverty, suffer similar consequences when they avoid seeking care because of this chilling effect. And of course, we've always seen this disproportionate impact of these abortion bans, which are familiar from the past as well. The chill that's created by these bans also means that we likely learn of only a fraction of the tragedies that are occurring since people face criminal and civil liability for reporting them. And as in the Comstock era, censorship hides the law's devastating impacts as states suppress their maternal mortality review boards and disinformation campaigns proliferate, spreading lies about the supposed dangers of abortion medications and procedures and even contraceptives. So I think in closing, I'll just say, I think that what we have learned from Comstockery is that these efforts at suppressing both reproductive freedom and expression about that freedom is part of a much larger political movement that threatens the foundations of our democracy. So I'll stop there. Thank you.
Thank you so much, Serena. And now, keeping right on schedule, moving on to David Cohen from Drexel. Thank you, David.
Thank you so much, and thank you to all the students involved in setting this up and having this symposium. I'm here talking about work that I did with Rachel Rebouchet, who's the dean at Temple Law School. We co-wrote one of the articles here, and she unfortunately couldn't be here today because of various other commitments that she had already. Basically, what we talk about is that we think that the work that Reva and Mayeri have done in Comstockery is a really fantastic intervention in the understanding of the Comstock Act, something that people were not focusing on before, but also that at this moment in time, the conservative anti-abortion courts probably are not going to care, unfortunately. So we advocate that the only real solution to the problem, and this is an immediate problem, is repeal of Comstock. And why do I say this is an immediate problem? I mean, starting Monday, we could see announcements that the Comstock Act is going to be enforced in the way that the revivalists that Mayeri and Reva write about support, and that every abortion provider, clinic, supporter, even patient is at risk of a Comstock Act violation with up to 5 years in jail. This is probably the #1 issue regarding abortion in the coming Trump administration, and with the change in the Department of Justice, this risk is real and it is coming fast. And it's not because of the contextualist, deeply historical analysis that Reva and Mayeri have given us in Comstockery, but rather because of the way the revivalists talk about the plain language of the statute, and they make it so simple in their argument, and they say that it is nothing but the simple language that any article or thing designed, adapted, or intended for producing abortion means literally what the language today sounds like it means. And they're making this argument in the open, and they're making this argument without equivocation. We saw this in amicus briefs filed before the Supreme Court in the Alliance for Hippocratic Medicine case, with a leading anti-abortion group saying this doesn't apply just to abortion drugs, it applies to any device or equipment at an abortion clinic because it all goes through the mail. An amicus brief from 145 members of Congress said the same thing. Project 2025 has made the same thing. Everything around abortion is at risk because of this interpretation of the Comstock Act, because everything is mailed. Nothing is grown in the backyard of an abortion clinic. Everything goes through the mail or UPS or FedEx, all of which are covered by the Comstock Act. Now, again, if the courts were principled and engaged in the kind of analysis that Comstockery gives us, we would feel very confident about the future, because any attempt to apply the Comstock Act starting Monday it would be shut down by the courts, because the courts would say that interpreting the language of the statute and the full complexity that is given to us by Comstockery would indicate that people who are producing, using anything to produce abortion today, not covered by the Comstock Act, because all of it is done in the context of lawful medical care. However, we have very strong evidence that the courts just aren't going to come through in this regard, at least when it comes to abortion. And 2 examples that Rachel and I point to in our article are Dobbs and the Alliance for Hippocratic Medicine case. And so in Dobbs, one of the central aspects of Dobbs was, if you look at the appendix that Justice Alito attached to the opinion, he showed all of the laws that were in existence before the ratification of the 14th Amendment in 1868. And he said that these laws showed that there were a large number of states, 28 out of 36 was his math, that banned abortion. And that because the bans on abortion existed before 1868, it's evidence that the 14th Amendment, and continued afterwards, it's evidence that the 14th Amendment did not protect any right to abortion. What I think is important to draw from that is that his analysis of those statutes is completely ahistorical, acontextual, and shows the kind of simple, modern looking back at old language and saying, I know what this means because I know English today, and I must know then what the people thought it meant back then. There have been many scholars who have shown us that the language of those abortion statutes before 1868 are much more complicated, was understood to be much more complicated than Justice Alito said they were. Scholars such as Aaron Tang have produced articles showing in detail about this language. And I just want to read to you one quote from him regarding the Alabama statute that Justice Alito relied on. And it has similar statutory interpretation analysis that Comstockery gives us, looking at the context of the time. He writes, few modern readers would think that the phrase used in the Alabama statute, any pregnant woman, actually refers only to some pregnant women, namely those whose fetuses had quickened. But if one is committed to an originalist approach to legal interpretation, faithful historical analysis forbids one to view historical sources from a present-day lens. So what he does, and others have done before him, looking at the specific language used in the statutes from before 1868, and showing that it was much more complex. Either it was limited to people whose pregnancies had reached quickening, it was limited to people who met other conditions, or it wasn't enforced at all. It was only enforced in certain circumstances where someone's life had been put at risk by the abortion procedure. There were varieties of contexts in this era in terms of how abortion bans or abortion laws were enforced that were not complete bans, as Justice Alito wrote that they were. Tang and others, or Tang argues in his article where he works through all of these abortion statutes, that the important thing to do is to immerse oneself in the linguistic and conceptual world of the authors and readers of the legal provision being studied. And this is what Comstockery does with Comstock. However, Justice Alito flatly ignores this kind of analysis. Although he touts the importance of history and tradition in understanding constitutional provisions, he does not look, and neither does anyone in the majority, look at the history and tradition in the context of the statutes he uses to justify the history and tradition of his constitutional analysis. This kind of contextual statutory analysis is just ignored by the court's conservatives in order to further their anti-abortion agenda. Exhibit number 2 is how the conservative anti-abortion judges ruled in Alliance for Hippocratic Medicine, or how they acted. We look at Judge Kaczmarek in the lower court, where he just said, I'm going to rely on the plain text of the Comstock Act. Looking specifically at the Comstock Act, he did not look at any history, tradition, context, any of the things that Comstockery gives us. Judge Ho in the Fifth Circuit, same thing. He says this is simple. The Comstock Act says one thing, that's what it must mean. Justices Alito and Thomas asked questions in oral argument. They did not rely on this in any of their decision-making in the Alliance for Hippocratic Medicine case, but they asked questions in oral argument. Justice Thomas saying it's obvious this just specifically covers these drugs, the Comstock Act. None of them showed any interest in contextual analysis when it came to language that they look at in the modern day as giving them a path for their agenda to restrict or ban abortion, even though they regularly nod to and consult history and tradition and other aspects of their analysis. So we are not confident at all that the courts, controlled by the judges who control them today, would give any effect to the analysis in Comstockery, as much as we are convinced by that analysis. And so as a result, we think that the important intervention here is that there needs to be a broad-based effort to repeal Comstock. The Comstock provision about contraception was repealed in 1971. That is no longer part of the law. We need to do the same today with the abortion provisions in Comstock, if not the law entirely, although I'll leave that aside for various reasons. Unfortunately, Democrats lost their opportunity when they controlled Congress previously, even when they controlled one house of Congress over the past couple years, because they have not been completely on board or even focused enough on the threat of Comstock or on board with the effort. There was indication that pro-choice Democrats feared that a failed repeal bill would be a signal to future courts that Congress agrees with the revivalists, and also that a failed repeal bill would embolden the anti-abortion movement to act further with respect to Comstock. We understand those risks. We think they can be mitigated, and we think they are outweighed by the importance of focusing on the American public on Comstock, on this law from 1871, passed in all of the contexts that we've been talking about, and making sure that the American people understand what it means, what it was about, and what it would mean today, and force people to defend a law with all of the sordid history that Reva and Mary uncover, and one that gives the Department of Justice the power to shut down all abortion, at least under the revivalist understanding of it, as well as for them to determine what is immoral and indecent, because that is also language in the Comstock Act. Because until this law is repealed, we are at the risk of the Thomases, Alitos, Kaczmaryks, Hoes of the world ignoring the lessons from Comstockery and instead going with a simplified, plain language analysis that could shut down abortion everywhere. Thank you.
Okay, thank you, David, for those sobering remarks. We are now going to take a few minutes for any questions. There are a couple questions in the chat, and one of them I might ask if any of you want to address, and the question is whether the Supreme Court's eagerness to expand the First Amendment exception for obscene materials in oral arguments of Free Speech Coalition versus Paxton suggests receptiveness to Comstockery. Does anyone have a thought about that?
Well, I do know that out of Texas, there was an effort to expand traditional conceptions of obscenity, and the briefing certainly headed in that history and tradition direction of expanding the regulation of obscenity. There was even one wild brief that reviewed the contents of Thomas Jefferson's library at Monticello, which was a remarkable brief. And it did look at the transcript of oral argument, which is still focused. The justices seem to be converging on defense of the traditional tiers of scrutiny. There's a lot of talk of tradition running through the transcript of oral argument. So if there's going to be a location in speechland where this would happen, obscenity would, sex talk for children would be provide an aperture. I guess I'll throw that out there.
Yeah, I mean, it's also worth emphasizing that Judge Kaczmarek, whom Professor mentioned in his paper, has also in dicta and in an opinion about drag performances and the First Amendment suggested that it would be better to kind of overhaul how we do free speech law altogether to focus on history and tradition. And he mentioned Comstock as a kind of touchstone in what history and tradition would look like, right? So sort of robust censorship of a variety of things we would no longer consider obscene as a touchstone, and how we should regulate things prospectively in determining that they're obscene. I mean, I think it's hard to know for sure. Obviously, it feels early, but I think certainly that it's worth emphasizing that when we're talking about Comstockery, we've been focusing today on abortion, but there is one of the appeals of the Comstock Act, of course, and of revivalism, is that the Comstock Act talks about other items for indecent or immoral use, a term that could be applied much more broadly than to abortion-related items. And so when we're thinking about the court's openness to Comstockery, it's absolutely right to think about it in terms that go beyond abortion, because that's really what we'd be talking about if the statute is in fact revived and enforced in the ways we've been discussing.
And just to build quickly off that, this is what I think could be so attractive in a really effective repeal campaign is, do we want the government judging what's indecent and immoral and really focusing on that language? And do we want these particular government actors deciding what's indecent and immoral and thinking all of the things that can be swept into that beyond anything related to abortion, whether it's contraception, even though the specific language about contraception has been omitted from the bill, whether it's anything about sex, whether it's anything about, treatment for HIV or anything related to LGBTQ equality, lingerie that people might order online. Anything could be determined immoral and indecent if you have someone like Ken Paxton ultimately, prosecuting people or any part of the, various figures that are part of considerations for the Trump DOJ.
Okay, I think, David, you have answered another question that came up at the Q&A from Debbie Bazarski, who directs our Center Center for LGBTQI faculty and staff at BU, and that is whether Comstock could be used now to go after LGBTQI organizations and publications, given the historical use of it to go after newsletters and magazines, et cetera. So I think you've kind of suggested that if you go down this path of talking about community decency and morality, that this could be a possibility.
Yeah, absolutely. I mean, in the Kasmeric case points to that, right? I mean, we've already seen a judge flagging that LGBTQA speech is one of the sort of heartland places that we would go next with revivalism.
But they haven't owned this as an agenda, but once they're in a position to enforce any piece of the statute from the executive branch, if that is a direction they go, they have an enormous amount of discretion about where and how they enlist it. Whether they do it on a speech axis or not, or go after PrEP drugs or otherwise, is all to be seen. But we're about to learn what their first interim group of executive orders looks like, and we'll see. Certainly it's the kind of thing, it's within the ambit of what it is that they've considered in their 2025 menu, but they're not going to spring all of that all at once, and they have politically prioritized things, and we don't know what that agenda looks like right now.
Okay, thanks everyone. Let's move on now. We'll come back to some more of the questions later. Let's turn now to our third speaker, Professor Laura Portuondo from University of Houston.
Hi, everyone. Thanks for the introduction, and thank you for the opportunity to participate in this wonderful symposium. Thanks to all the great scholars here and also the students for their hard and very rapid work editing these pieces to get them out before the election, at least some of them. So I'm very happy with my spot here in the order of presentation, because I think that my contribution both builds on some of the democracy themes that Serena was speaking about, as well as some of the kind of practical political considerations that David was talking about. So my contribution is really plugging this wonderful Comstockery article into broader questions of democracy, and particularly the Supreme Court's claims about democracy in Dobbs versus Jackson Women's Health. I think there's some great synergy here with Comstockery and also some other work on democracy and Dobbs that's recently been done by professors Melissa Murray and Kate Shaw, Dobbs and Democracy, thinking broadly about what kind of the court's claims about democracy mean in light of recent developments in reproductive law. So when the Supreme Court eliminated the right to abortion in Dobbs versus Jackson Women's Health, it very much claimed the mantle of democracy. It said that it was giving the power over abortion policy back to voters. The court declared that no longer would it allow its own ardent views about liberty, that's a quote, to govern the abortion question. Instead, the court explained that it would ensure that voters, and that includes women on both sides of the abortion issue, as the court put it, would be empowered to seek to affect the legislative process. So the court's very much claiming the mantle of democracy here, and you can hear there are echoes of longstanding conservative characterizations of Roe itself as anti-democratic and as judicial overreach, right? So the Supreme Court in Dobbs is saying we're giving the power over abortion back to the people. We are engaged in a practice of judicial restraint here. So I think that these claims that Dobbs made about democracy are in direct tension with the kind of broad interpretation of Comstock that Reva and Mayeri discuss in their article. As they show, and as they just explained, some litigants are trying to use Comstock basically as a way to displace democracy. They are hoping that they can use a statute from the 1800s to pass the kind of total abortion ban that they can't persuade voters to adopt today. So where you can't win in the field of democracy. They're hoping they can kind of run to the courts and get courts to enforce the anti-abortion policies that they prefer, even though, as Mary discussed, there's broad evidence that people don't support these kinds of draconian abortion bans. So I build on this and try to say that in some ways the situation is even worse than that, right? It's not just that interpreting the Comstock Act in this very broad way would impose this abortion ban that people haven't been willing to adopt. In fact, it would displace a broad range of protections for abortion that are in place, not just in blue states, but in red states. It would wipe out innumerable laws that afford some kind of protection to abortion across the country. In this way, this broad interpretation of Comstock would ignore the will of millions of voters who have expressed a clear desire to protect abortion. And one way to think about this is, I'm speaking to you here from Texas. This would actually impose a stricter abortion policy than we have here in Texas. Texas has limited and, in my opinion, inadequate exceptions to protect the life and, in some circumstances, the health of a pregnant person. This total abortion ban would get rid of those, right? So this is more extreme even than the kind of most extreme abortion bans in states. So you can see this is displacing the will not just of, New York voters, California voters, even voters here in Texas. So this situation, I think, is particularly stark when you think about the context of recent ballot initiatives across the country. As some people here may be aware, there have been a broad range of grassroots movements across the country in response to Dobbs, trying to get measures onto state ballots, providing protections for abortion in state constitutions. Again, these have not just been in blue states, they've been in red states, as well as blue states, as well as purple states. And these ballot initiatives have been nearly uniformly successful. Even in states where they have failed, like Florida, for example, there was a majority vote in support of those amendments. And some of these protections are really broad and in surprising ways. I encourage everyone here to go look at the Missouri ballot initiative that was adopted. It's incredibly broad, robust protections for reproductive freedom. So Comstock would wipe out these very recent expressions of democratic will and support for abortion access. This would, of course, directly contravene the Supreme Court's claims in Dobbs that it is returning the question of abortion to the people. Now, of course, a court adopting this broad interpretation of Comstock might try to say that no, it is in fact engaged in a democratic project. It's just enforcing that democratic will that is embodied in the Comstock Act itself. So this is unpersuasive for two primary reasons. The first reason, and Serena talked a bit about this, is that the Comstock Act, enacted in the 1800s, suffers from some serious democratic defects as compared to contemporary abortion protective legislation. At that time, unlike today, women were formally prohibited from voting, and men of color lacked meaningful access to the ballot. And while contemporary democracy is by no means perfect, abortion protective legislation today far better represents the will of the people than an anti-vice law from the 1800s. But I think there's also a second problem with a kind of democratic appeal to Comstock Act as a democratic statute, and that's what Reva and Mary identify, which is that this is not really what the Comstock Act was ever intended to be, right? The Comstock Act was not written as an abortion ban, it was not intended to be an abortion ban, and it was never interpreted that way. So interpreting the Comstock Act to impose a total abortion ban throughout the country would not even reflect the will of the electorate of that time. So what would it reflect instead? Well, it would reflect the will of judges. Applying the Comstock Act as a national abortion ban would, in some eliminate the popular control over abortion policy that Dobbs professed to give. It would, in turn, empower judges in the manner that Dobbs professed to condemn. This power shift from the people to unelected judges would not represent some coherent vision of judicial review. It would not, for example, correct for democratic process defects, as Professors Siegel and Ziegler argue that courts did when they first intervened to narrow the Comstock Act. Judicial enforcement of the Comstock Act as a nationwide abortion ban would instead represent modern judges substituting their, and I'm quoting Dobbs here, own ardent views about the liberty that Americans should enjoy for the views of democracy. This would reveal Dobbs's purported commitment to democracy to be hollow. Right? Voters can and should control abortion policy, but only if they choose to restrict abortion. It would suggest, moreover, that Dobbs was not about democracy at all, but instead about imposing judicial value judgments about liberty and equality that the vast majority of Americans disagree with.
Thank you so much, Laura, for bringing that down to various states and the impact on not only blue states, but also red states. And now finally, my colleague, Professor Nicole Huberfeld from the law school, as well as the School of Public Health.
Thank you, Linda, and thanks to everyone who's joining us today. It is really a pleasure to be here. I want to echo the praise and the thanks for Reva and Mary's incredibly hard work, for their deep thinking. I want to also key my remarks to a reflection on their companion article, which is Abortion's New Criminalization. So I'm not just thinking of the deep history that's provided in the Comstockery article, but also in Abortion's New Criminalization, which I recommend to everyone if you haven't read it yet. So I have really 3 points to make, and in many ways, they are a friendly amendment, if you will, or building on this history of the Comstock Act that is entirely convincing. And this extra dimension that I want to add is that there is more to say about the assertion, the correct assertion in my view, that obscenity very intentionally did not include healthcare. And so I have really 3 different ways to think about this that trace in very broad strokes a history of the regulation of physicians and the medical professions. So first is that this history reflects that physician power was beginning to be very real at the same time that the Comstock Act efforts were beginning. So there's a coincidence that's relevant there. Then that physicians were wildly successful in building the medical profession's power, turning authority over a learned profession into what Paul Starr famously called social privilege, economic power, and political power. And that lasted for nearly a century. But by the time that Roe was decided, that power was being challenged and questioned in a number of ways, perhaps most importantly, including a turn away from paternalism toward patient autonomy. And then finally, I couldn't agree more that the Comstock Act clearly was not a national trigger law like we saw in some states, just sitting there on the books waiting to ban abortion when Roe was overturned. But I agree with David that we shouldn't be complacent in believing that courts are going to read and understand this history that Reva and Mary have given to us. In part, I think this is reflected in the fact that courts are no longer deferential to the profession of healthcare, whether it's physicians or other healthcare providers. What we're seeing is that in particular, the power of doctors is waning, and it has been for a couple of decades. So let me talk about the first point first. The support for arguments that Comstock didn't regulate physicians or the physician-patient relationship, and why that importantly coincides with the development of being a profession. So in the article, we learn that 1873 was a pivot point when Woodhull's acquittal coincided with, or at least pushed, some efforts to change the approach to obscenity on the part of Comstock and others who supported him. This timing coincided with physicians urging recognition of the profession through ethics and through law. They had been unsuccessful until roughly 1870 or so in constructing a profession. And this is partially reflected in the fact that the AMA was founded, the American Medical Association was founded in 1847, but it really didn't have any meaningful participation in the regulation of medicine until roughly 1873, when the Judicial Council was created for dealing with ethical controversies. And then about 10 years later, the Journal of the American Medical Association was created to publish and disseminate scientific information for medical professionals. So construction of the profession started arguably in the same year that Anthony Comstock was feeling motivated to try to eliminate obscenity. Simultaneously, starting in roughly 1870, there was a push on the part of physicians to get states to regulate through licensure. And this did a couple of things. It enforced self-regulation of the profession by physicians, and it made it so that there was deference baked into state laws regulating medicine. This deference was justified as quality measures because physicians knew best what physicians knew. And so licensure was deemed a quality measure that would best be enforced by those in the profession. Probably needless to say, this also helped to develop the guild-like status of physicians in the United States. Finally, there's a third feature to this history, which is that the construction of the profession and the push for states to regulate through licensure also roughly coincided with formalization of medical education. Even before the 1910 Flexner Report significantly restricted what medical schools could be, we had schools like Harvard creating a much more formal and rigorous medical education, and that led to states requiring a medical diploma for licensure, and then licensure was in turn effectively self-regulated by the doctors themselves. And so when we see that this formalization of medical education was occurring, simultaneously, some irregulars, meaning those who were not physicians, got absorbed into being physicians like homeopaths. But on the other hand, others who were effectively practicing medicine in different ways, like midwives, got pushed out of the profession. So this encouraged elite and exclusive education, and it rejected women and people of color. The AMA infamously in its history rejected women, Black people, and other people of color. And this, to complement Laura's story, further elevated the undemocratic voices in regulation of medicine of all sorts, not just what it meant to be a physician, but what it meant to be a midwife, what it meant to be a nurse, what it meant to be a chiropractor. And so physicians became gatekeepers and arbiters of healthcare. And this is very consistent with the history that we read in the Comstockery article. It's notable that this long rise in physician power occurred for a good portion of the 20th century. It's almost a century-long story. And in addition to consolidating authority through medical education and licensure, physicians were able to control the prices that they could demand for their services and the forms of payment that they could demand for their services. Famously, they fought national health insurance when President Truman argued for it after World War II. And they fought Medicare as being socialized medicine, though obviously they lost that battle in 1965. However, when we're thinking about this second phase of physicians being a dominant and deferred to regulated body, we also see that there is something critical that happened after World War II, and that's the Nuremberg trials. The Nuremberg trials, which were called by some the Nazi doctor trials, led to the Nuremberg Code, which advanced informed consent, not only on the part of people participating in clinical trials, but also on the part of patients in medical settings. So by the early 1970s, physician paternalism or beneficence, depending on your perspective, was being questioned deeply, and patient autonomy was ascendant. This was a long arc, but we saw that the long deference to physicians that is reflected in cases like Griswold versus Connecticut and in Roe and in Doe versus Bolton led to an understandable perception that physician-patient privacy was guided by the physician. Yet, Roe was actually decided on the cusp of the end of deference to physician paternalism. And it's a bookend of sorts. So by the 1980s, patient autonomy and informed consent were the legal and ethical standards in practice of medicine, bolstered by things like the Belmont Report in 1976, which made it clear that patient autonomy was essential to participating in clinical trials and in medical care. So by the time Casey was decided, the physician right to treat was an outdated way to think about how medicine occurred. And it may have opened the door to state regulation in the name of health that we saw after Casey that was used to limit access to care rather than enhance it. It also, in my view, made it so that regulating the medical profession in a restrictive and non-scientific way became more possible. We think of, for example, scripted required informed consent, where the physician is told that he must deliver to the patient information that is scientifically untrue, like abortions cause breast cancer. We also know that there were later laws like TRAP laws, targeted regulation of abortion provider laws, that also do not enhance access to healthcare. And so it may be that the height of this lack of deference to the medical profession during the Roe and Casey regime anyway, was Gonzalez versus Carhart, when the Supreme Court blessed the Federal Partial Birth Abortion Ban Act, calling doctors abortion doctors rather than physicians, and rejecting the weight of medical evidence that this later term abortion procedure was sometimes the safest way to proceed. So now, what do we see? State regulation of medicine is frankly mayhem at this time. States have been drafting abortion laws that totally disregard medical expertise and evidence, and this is overflowing into other areas of medical regulation. We could certainly point to what's happening in the space of gender-affirming care, but also this exists not only at the state level, but at the federal level too. We see resistance to funding family planning through Title X, excluding Planned Parenthood from Medicaid, exceptions to abortion laws that purposefully are opaque to healthcare providers, even when physicians ask their own regulators to make it clear when they may act lawfully, regulators have been non-responsive. And so while I couldn't agree more that this Comstock history is surely correct, it may not matter in an age of declining respect for medicine and science. Further, states are emboldened by Dobbs. They are emboldened to argue that they have total power over the regulation of medicine. And we are seeing this across all kinds of litigation that is sitting in the federal courts right now. Now, we could argue in some states this means that you get laws like interstate shield laws, and those protect the profession. But on the other hand, we already see that the practice of medicine is eroding in abortion ban and restriction states. People who are choosing their medical residencies are choosing non-abortion ban states, and this has happened in the last couple of years after Dobbs. And at the federal level, we're likely to see erosion in the new Trump administration, as we've already heard. We can expect that the EMTALA policy will be revoked. We can see that Section 1557 civil rights regulations probably will be rescinded. There will likely be a global gag rule. We will probably see that mifepristone is limited in some way, and we will probably see that states can take a narrow view of what they must pay for under the Hyde Amendment for Medicaid participants. In other words, I think we can expect that the Comstock Act may be treated like a national trigger law, but I sincerely hope that Reva and Mary's work will convince at least some courts. Thank you.
Another sobering presentation. Thank you, Nicole. Okay, so we have about 15 minutes left. I'd like to take a few questions and then reserve time for Mary and Reva. So a couple questions. First of all, one attendee writes, adding on to Professor Huberfeld's point, the professionalism of medicine excluded minorities. The Flexner report led to the closure of 5 of the US 7 medical schools at HBCUs. Thank you for that. And here's a question for David from Katie Crashaw. What are the risk mitigation strategies you propose to preempt emboldening enforcement or courts finding legitimacy and repeal failure?
So we think that using a really strong preamble to any repeal bill would do the trick. Using language that is very clear says that nothing in this this bill indicates an agreement with the revivalist interpretation. In fact, the circuit courts from the 1920s and 30s, and even referring to Comstockery, got it right that this was never intended to accomplish the goals that the current discussion indicates from some people. So very clear information in the beginning of the bill indicating that is not being introduced because of agreement with this interpretation, but rather because of fear that some courts would adopt this interpretation. I think that would make it clear that this was being done for that purpose and that no one signing on to the bill would be indicating an agreement.
And people want to see that language. It's in David and Rachel's essay that's online. There's another question. How does the FDA's approval of a medicated pill like mifepristone impact its availability in states that have enacted laws banning or restricted its use? I'm sure that we could talk another 2 hours about that, but does anyone have a quick response on that? Nicole?
So this is, to me, one of the intractable conflicts that's arising in the wake of Dobbs, that there is a federal determination, I mean, the FDA exists for a reason, that this law is, that this drug is safe and efficacious for the purpose for which it is created. States do not have contemporaneous authority to decide differently, but after Dobbs, they have been claiming that they have total power over the regulation of medicine. And they are pointing to cases like Washington versus Glucksberg for this assertion, which of course the court in Dobbs pointed to for its history and tradition analysis. And these are cases that don't necessarily support the assertion that states have total power over regulation of medicine. But this is something that I think courts are going to have to resolve, because I don't think we have a clean answer to this that exists in doctrine right now.
And just to follow up on that, there are a couple cases working their way through the lower courts raising these issues. There's a case out of West Virginia and a case out of North Carolina, both on appeal to the Fourth Circuit, that raised the question of whether state regulation of mifepristone through either a general abortion ban or a specific, that's the context of West Virginia, or in North Carolina, specific rules that go above and beyond what the FDA requires for mifepristone. That's what North Carolina's law says, that whether these state laws are preempted by the FDA's approval of mifepristone. And we don't have decisions from the Fourth Circuit yet, but this is being litigated.
Okay, so I'm going to put one question to you from our co-sponsor, BU Law, If One How, and then just turn it over to Mary and Reva. And Laura, you might want to take the first crack at this. And it's basically, would grassroots mobilization of ordinary people be enough to put pressure on judges to consider the popular support for abortion, or will effective resistance have to come top down from legislators?
I mean, I think in some ways it's all of the above, right? I do think, of course, bottom up mobilization is really important, and you can see that in these ballot measures that have been passed throughout the country, right? Of course, there's always the looming threat of a court coming down and saying, actually, never mind, those are no good. And in fact, you can see some legislatures already trying to find ways to narrow these broad protections for abortion access that voters pass through direct democratic measures. So I think that it is incredibly important to have this popular mobilization and resistance to this broad and anti-democratic interpretation of Comstock. And, I think part of it is illuminating the ways in which the kind of legal arguments that are being made behind Comstock are essentially bunk, right? Or certainly inconsistent with the principles that they are purporting to promote. At the same time, one of the reasons that the anti-abortion movement favors using these kinds of anti-democratic means to restrict abortion is precisely because they don't require consent of a majority, right? They are ways to get around popular mobilization and resistance. So part of it is also, I think, thinking about broader structural reforms to make both our legislatures as well as our courts more democratic and responsive to those kinds of political mobilizations. Because if you have a total breakdown between courts, for example, and democracy, there's no way for that political mobilization to make an impact. So I think it's both and.
Serena, I wondered if you wanted to say anything, given all the work you've done on developments after Dobbs, including in courts like Pennsylvania.
Sorry, I was having trouble unmuting myself. Yes, well, I do think we've seen, as Laura was pointing to, some enormously encouraging developments at the state level. And while many of those have been more about kind of grassroots mobilization and voters, sort of voicing their preferences about access to reproductive health care, we have seen it to some degree in state courts as well. And Linda just referred to the Pennsylvania Supreme Court's decision from about a year ago, maybe a little less than a year ago, in a case that David was very deeply involved in and can certainly say more about. But a really, pretty fantastic, set of opinions in that case that, interestingly, to a degree that I certainly hadn't seen before, draw upon scholarship like Reva's and Mary's, and in particular historical scholarship and reproductive justice scholarship that, shows that sometimes these academic efforts can, I think, have an impact in courts too.
And draws on Pennsylvania's Equal Rights Amendment. So we only have about 7 minutes. So I want to give Reva and Mary a chance to come back in with anything they'd like to add in light of the commentaries or the audience questions.
Well, we haven't consulted about this in any way, except we did have some few things to say about courts and politics. Maybe we want to just say a few words about the other papers first. I'll just say a few things, then we can maybe go in that direction, Mary. I don't know. First of all, we wanted to again thank all of you who brought this together. It was an amazing array of voices and totally impressive set of comments. We wanted to commend everyone to read Serena's paper, The Critical Role of History After Dobbs. It's really wide-ranging, significant review, more than any of us could sum in a minute or 20. But it really does give some suggestion of the wide-ranging possibilities of drawing on the past critically in a wildly different way than the court's history and tradition jurisprudence does. And in the process, both shows the power of critique, but also of the possibility of what she calls positive, not just negative precedent. That is to say, focusing on past agency in the past, people, relatively disempowered people acting constructively, making change. And we can see new heroes, agents to valorize in the past around which we can build stories. It's really important work. So wanted to put that on the table. David, and it's a total change maker. Can't say enough about the work that he and Rachel are doing. I will engage here and say something really informal in saying that we know that there's obstacles, to put it politely, about the construction of the Congress right now, so far as getting repeal off the ground, and also, let's just say, a conversation on the left about how to proceed on that question. And I want to emphasize the importance of education both public within and outside of movements about Comstock, because I still encounter what I would call the dentist problem, where you talk to the dentist about Comstock and they don't know. So, you know, in other words, just like people had to learn about Project 2025, there's a lot to learn about Comstock, and there are ways to do that, including enlisting media and all the ways that Project 2025 was brought to the American people. I think that that kind of work needs to be done. I also think it's really important. Mary and I spent a lot of time focusing on how to simplify the textual arguments so you could talk about obscenity and health and a few other simple frames to explain to people why it's not enough to focus on the word abortion in the text of the statute. It really doesn't fairly read lead itself to a ban, you know, but I'm not going to take more time, but simply to say there's no reason to repeat their frames in the process. Even if repeal is needed, there's a couple units of meaning that could be spread out there and need to be, as the other conversation about repeal is going, and about the importance of a preamble. Storytelling is always critical. Also, and the last thing I'll say to Nicole, so much you put on the table, there's no way, if we're taking just a few minutes to respond. I do want to say that if we're going to engage with the court on history and tradition, this long history you're talking about does tell us that the medical profession did have authority in the past that it doesn't today. So the exceptions gave doctors authority that today they're not getting in court, and therefore that there's way more space in this history and tradition method to credit what it is that the statutes, even the ban statutes, are allowing by way of practice to protect people who are being sent to bleed out in parking lots. So, I mean, whether we're talking about our paper or there's now a claim in federal court that the Loring Project is brought, or, you know, without EMTALA, we're going to need to figure out how to deal with this project. So, Mary, why don't you take up a few strands of the democracy thing, and I'll come in because I don't want to monopolize this. So we could maybe take up Laura, or I don't know where you want to go in this, you know?
Yeah, I mean, one of the things we noticed in all the papers, which I mean, I'll echo Reva's point, are really fantastic. And it's such a treat to have so many smart people engage with our work, which was really a labor, maybe not a labor of love, but definitely a labor. We picked up obviously on the kind of really rich discussions of courts and legislatures and democracy, and the idea that there's something fundamentally awry in our democracy that we need to be addressing. And so when Reva and I were discussing this, we were noticing all the different ways that courts operate in our story, right? In the 1930s, we have courts that are pretty responsive to calls for change, responsive to resistance to laws that have been put in place by a small percentage of people in the population. We saw two courts that were somewhat responsive to movements as well in the substantive due process decisions of the 1960s and 70s, is certainly more responsive than legislatures because of legislative lockup, even as they sort of buried the stories of some of the people who were inspiring their decisions. But we also see some of the kind of cautionary stories that Laura points to, like Judge Kaczmarek or Judge Ho, and frankly that David points to too, who are plainly ignoring popular will and using a law like Comstock to subvert it. So one of the things that was striking to us was reading Laura's piece together with Scott Cummings' piece, which is part of the online symposium, and putting those two things in dialogue with one another, which shows that, of course, courts are a potentially broken part of our democracy, but other things are potentially problematic too. And we see that in the response to the very kinds of ballot initiatives we've discussed. We see it in the filibuster in Congress. We see it in gerrymandering in state legislatures. We see it in all the steps that abortion opponents have taken to subvert ballot measures, including those that use Comstock itself in places like Missouri and Arizona, to undermine the will of the people as it was just expressed in November. And we see it too in the alliance of or work that abortion opponents and other opponents of reproductive rights have done on issues from voter ID to prohibiting mail-in balloting to eliminating campaign finance regulations. So all of that made us think in kind of deep ways about how if this is a story about democracy, as Serena says, which I think is spot on, what kind of democracy related work advocates for reproductive rights really need to be doing? And the answer, it seems to us, has to be, yes, and, it's court reform and legislative reform and all other kinds of reform. The only other thing I think that there's a theme that interested us that picks up on the papers, and Serena's paper in particular, is how to do this kind of balancing act of being critical of what the court has done with history and tradition, and acknowledge, as Nicole and others do, that our present moment doesn't always recognize the same kinds of traditions that would have been resonant in the past, without kind of ceding the idea of history and tradition altogether to people with whom we disagree. And that's something certainly we're doing in Comstockery, and we're doing in the paper that Nicole mentioned, abortion's new criminalization, which is coming out in the Virginia Law Review. But it's not a straightforward project. So it's something that we're really happy to see so many smart people engaging in with us as part of this seminar, but not just as part of this seminar.
I would like to close up by saying something to the students who happen to be listening, to the If When How students and any others, which is, even though the sense of these observations that Mary was just making was, as I like to put it when I'm talking to my colleague Sam Moyne, who's a huge court critic, well, yes, courts are broken, but so is democracy. That can sound quite grim to the next generation. But in fact, if you look around in this conflict, you can see state courts pushing back at and giving different results than the United States Supreme Court has. And you can see state legislatures responding. And as many features of the democracy as you see broken, you can also see evidence of really robust, really powerful, really wonderful, functioning and healthy elements of the system showing us the best it can be. I mean, I have read some of the resisting state judgments critical of Dobbs' method, saying things about originalism I don't think I've ever seen a United States government official ever say. So there are reasons to fight for the future and to understand that those who are running the United States Supreme Court got there because they were alienated from the Warren Court, and that so long as we can hang on to our democracy and this planet, that it's a story of change, and you should be in it for the longer run because it's yours too. So I didn't want to sound too grim in the last analysis. There are Americans talking about abortion like it's a right and a freedom that is American. And that, Sam Alito could not stop. That was the nation's response to Dobbs. So I just want to make you see that there's really robust forms of change in this story. Okay?
Okay, Reva, thank you for leaving us on a more uplifting note about possibility and message to our students and any other students who are listening or maybe watching this in the future. I want to thank our co-hosts, BU Law Review Online, BU If One How, thank all our terrific panelists. Remind everyone that this written symposium is up on BU Law Review's website. And there's also a piece by Michael Dorff and Scott Cummings, who couldn't join us today. And there will be a recording of this that you can share with anyone you'd like to, which will be on BU PRJ's website and the Law Review's website. So thank you, everyone, for a wonderful conversation. And thank you, everyone, for tuning in, and go out in the world inspired by Reva's final closing remarks.